Okay, picture this. A neutral country, the one famous for mountains and diplomacy, decides to take on a global superpower, and they do it at the world's highest court. I know, it sounds like something straight out of a spy novel, right? But this is the incredible, true story of a super high-stakes legal battle that went down right in the middle of the Cold War. So let's dive into the fascinating case of Interhandel.
And here it is, the official record from the International Court of Justice. Back in 1957, Switzerland did what most would consider unthinkable. It filed a case against the United States of America. The whole fight was over a company called Interhandel, and believe me, it would push the very limits of international law.
So, what on earth could lead one nation to sue another in such a dramatic way? Well, it all boiled down to one very specific and very, very valuable demand. This is the actual language from a telegram sent by the court, and it gets right to the point. Switzerland was demanding that the U.S. government restitute assets, which is just a fancy way of saying give back property it had taken from this Swiss company, Interhandel. And we're not talking about pocket change here. The assets seized were valued at over $100 million back in the 1950s. That's a staggering amount of money. It included a ton of cash in American banks, and, this is the kicker, a nearly 90% controlling stake in a major American corporation. The stakes were just absolutely astronomical. With so much on the line, you can bet the opening moves in this legal battle were fast and super strategic. It was like watching a high-stakes chess match play out through diplomatic cables and court filings. Just look at how fast this all happened. October 2nd, the case is filed. The very next day, Switzerland makes another urgent request. By the 9th, the U.S. has its top legal eagles on the job, and by October 12th, just 10 days in, the two nations are already arguing in front of the court in the Netherlands. This thing was moving at lightning speed. So that first big move was all about Switzerland's request for interim measures. See, they were terrified that the U.S. was just going to sell off the company's assets before the International Court could even figure out who the real owner was. Their number one goal was to get a court order to just freeze everything. The United States, though, showed up with a really powerful countermove. They weren't there to argue about who owned what, not yet anyway. Instead, their whole plan was to challenge the court's right to even hear the case in the first place. Their strategy was to file something called a preliminary objection. It's a legal move that basically says, whoa, hold on a second. This case doesn't belong here. You, the International Court, you don't have jurisdiction. So the U.S. was trying to get the whole thing thrown out on a technicality before it even really began.
And this was their big argument, based on a really core principle of international law. The U.S. claimed that Interhandel had not exhausted its local remedies. That's not just a tactic, it's a fundamental rule designed to respect a country's own courts. The idea is simple, really. You have to finish your fight at home before you can go crying to the World Court for help.
And this, my friends, is where the story gets really interesting. Because to understand why the U.S. was making this argument, we have to look at this other legal battle, the one that was happening inside the United States itself. It holds the key to this whole international mystery.
This is where it all connects. On the left, you've got the case at The Hague, and on the right, a decision from the U.S. Supreme Court. While these two countries were arguing on the world stage, the company itself was fighting a totally separate case all the way up to the highest court in America. And these two worlds were about to collide.
So the U.S. Supreme Court opinion finally spills the beans on the backstory. Why did the U.S. seize these assets in the first place? Well, it all went down during World War II. The U.S. government was convinced that Interhandel was just a front for IG Farben, a gigantic German chemical company, making it an enemy national. So they seized the assets under the Trading with the Enemy Act. This created a completely impossible situation for the company, a classic catch-22. The U.S. courts are saying, hey, to prove you're actually Swiss, just show us your secret bank records. But Swiss law says, whoa there, revealing those secret bank records is literally a crime. So to stop this crime from happening, the Swiss government itself steps in and basically confiscates the documents. Interhandel was trapped between two totally conflicting national laws. Now, at first, a lower U.S. court had thrown out Interhandel's case because they didn't produce the documents. But then, in a pretty stunning reversal on June 16, 1958, the U.S. Supreme Court brought the case back to life. They ruled that the company's failure wasn't them just refusing to cooperate. It was because the Swiss government had stepped in. The legal fight in America was back on. And that single decision, made in a courtroom in Washington, D.C., sent massive shockwaves across the Atlantic. It completely changed the game for both Switzerland and the United States over at The Hague.
Okay, so just think about this. Before the Supreme Court ruling, Switzerland could argue, hey, the case in the U.S. is finished, so we've exhausted our options, it's time for the ICJ. But after that ruling, the U.S. case was suddenly active again. This gave the United States the perfect argument. They could now walk into the ICJ and say, see, Interhandel has not exhausted its local remedies. Their case is still alive in our courts. You have no jurisdiction here.
So you see, in the end, this was about so much more than just one company's assets. The Interhandel case became this classic example of the really complex and often conflicting relationship between a nation's own internal laws and the authority of international courts.
And that leaves us with this huge question that lawyers and diplomats are still wrestling with today. The case forces us to ask, in a world full of sovereign nations, each with its own set of laws, what happens when those laws make it literally impossible to play by another country's rules? And can international law ever really fix a problem that's so deeply trapped at the national level? It's a lot to think about.